already, but if
you mind
one
calling them
person
in,
comes
or-
in tomorrow and watch it, can you share his link?
It's for appointment of counsel also.
Okay.
Here in counsel. So Mr. Anderson is present. Duty Attorney Jim Gavigan is here, and along with Assistant Attorney General Alicia Willis. If you could all just identify yourselves for the record. Good afternoon, Your Honor. Alicia Willis.
Teaser, which kind of sounds like teaser.
Attorney James Gavigan, the duty attorney today, Your Honor.
Okay, Mr. Gavigan.
Your Honor, Raymond Saig, I filed my motion as a result of a request by Mr. Anderson.
Okay. Do we have that motion?
Look.
All right. Thank you.
Always 3 names for serial killers.
Okay, Mr. Saig, I'm going to allow your motion to withdraw and appoint Mr. Gavigan.
Thank you, Your Honor.
Teaser, which sounds like teaser,
Mr. Gavigan,
is a Danish.
have you had an opportunity to talk to
Nickname for
Attorney Willis about the case?
Yes, I have, Your Honor.
Okay. What do you think is the appropriate thing for us to next schedule?
Just a pretrial conference, Your Honor. I just want to review the material, speak to the defendant, Your Honor. And is my understanding that the defendant resides out of state in Ohio. We're asking either that he can appear by Zoom on the next date or that his presence be waived, Your Honor, either or.
Okay. Any problem with Mr. Anderson appearing by Zoom?
That's agreeable to the Commonwealth, Your Honor.
All right. So we'll pick another date for a pretrial conference, and Mr. Anderson, you can appear by Zoom. All right. What date would you like?
December, an early December date that might be available to court, the 2nd or the 3rd or the 4th of December.
3rd?
We could try that, Your Honor. I have a trial the week before Thanksgiving that will most likely run into that week. If we could do December 10th, that would be easier on my schedule.
December 10th at 2 p.m., Your Honor.
Okay, great.
Thank you. And I'm sorry, we did try and confirm dates, but it was a little hectic earlier.
No problem.
Mr. Anderson, Attorney Saig has been allowed to withdraw. Attorney Jim Gavigan has been appointed to represent you. With this appointment, there is a legal counsel fee in the amount of $150. Your matter is continued to December 10th at 2 p.m. for a pretrial conference. You are able to Zoom if, Attorney Gavigan, if you just email me the day before, I can send you the Zoom information. Yes, or the same one for this courtroom.
Okay.
Okay. Thank you, sir.
Thank you, Your Honor. Thank you, Madam Clerk.
Okay.
3 o'clock in the interpreter. She's tied up in the main till 3 p.m.
That, so Mr. Gavigan, will you be able to help us on that arraignment and lockup? Thank you so much. Okay, we do have some probation matters we can do. Mr. Gavigan, you're ready?
Yes.
Or sorry,
Come on.
Gavin Flanagan, sorry. This will be number 6. No, number 5. Commonwealth versus Vladimir Sylvain, 23 PT 32.
Yes, this is Judge Corrupt.
The parties could please come forward and identify themselves.
And we're
correctly.
going through all the cases until we get to
Gavin Flanagan, probation.
Okay, Mr. Flanagan. Where's Mr. Sylvain? Mr. Sylvain. Okay, good morning.
Good morning.
Afternoon, I guess. Afternoon. So the violation here is a new case out of Stoughton, operating a motor vehicle with a suspended license.
Yes, Your Honor. And I did bring, it was on the 9th that I did hand you up from the R&B on the 9th of that night. I guess there was fees that weren't paid. He did pay that night. The case was dismissed the next, the arraignment date.
Okay.
So just, and, he did take the initiative. He emailed me that night, everything that was on there. So.
All right.
That's weird. If you have to pay a fee for.
I appreciate you bringing it to my attention. Is there any reason I shouldn't just dismiss the probation violation?
No other reason, Your Honor.
Okay. I dismiss the probation violation, and you'll be subject to continued probation on the same conditions. Okay?
Thank you, Your Honor.
Very good.
Some call it
So then
this
the
event, but that's not
violation is
Copenhagen.
dismissed, and you are discharged on probation with the same terms and conditions. Thank you, sir. Next, before the court, number 6, Commonwealth versus Michael Cote, 23 PT 122. Secretary is present. Mr. Gavigan, are
It's
you
probably
looking at
because
this?
it's a motion hearing.
Okay.
All of this is just,
Or, oh, it's just a motion to travel?
it's
Okay,
just,
probation officer,
all
Kia
the
Brantley. Did I give you this or no?
in and out
Is there a
paperwork.
written motion?
Yes,
Not live.
Your
I will hear muffins.
Good afternoon, Your Honor. Kia Brantley for probation.
Okay, let me just take a look. I have a written, handwritten request by Mr. Cote. How do you say, is that how you say your last name? Cody.
Yes, this is Zoom, so
Okay, bear with me one
there are no
second.
breaks in this. So, we're just waiting for Aidan's to come alive, or Karen's. So, anyone we know here, Aidan's here, AML, that's the trial channels here, Mark Bettero's here, Roberta Glass, iPhone, I know that name. Where's old Brandy?
What does it mean to drop trailers? What is that, what do you do?
Well, I haul a lot of festival trailers, the festivals, drop them and leave, and then go get another one and bring it back. Usually about 3-4 trailers to a festival. And then I go and get them when the festival is over, but
Roberta
it dries
Glass is
up
the
around
suck.
September. So I've been getting a lot of calls to do stuff out of state.
And how far do you have to go?
Sometimes I get calls to Alabama, Mississippi, Texas, Florida.
All right,
We're not making it a conspiracy. We're just saying this is how it goes. Oh, she's in
you're
Kiana.
currently under conditions that allow you to travel to New Hampshire, Maine, and Rhode Island for work, provided that you tell the probation officer the day before. Yeah, okay,
Oh, that's why. Thank you, Gail. I thought it was just someone who
Brantley,
wanted
is
to
there any
change
reason that I
counsel.
shouldn't allow Mr. Cody to travel more broadly?
No, Your Honor, Mr. Cody has
I think
been,
it's because
in
Karen's is a real
compliance.
hearing. This is
He
just-
fulfilled all his terms of probation. I have been his probation officer since his release in April of 2023. We did come before the court, I believe it was in 2023, in regards
Oh,
to
that's
the
Melon
traveling
Letter.
within
Oh,
New England. He has complied with those. There hasn't been any
I
issues.
was thinking, I
The
thought it was
person
for
that
the
he hauled the trailers for has contacted me as well in order to verify basically what
You should
Mr.
have seen
Cody
the
was saying and
reconstruction,
their need. Apparently, he's very good at what he does, so he seems to be highly sought after. So probation doesn't have any objections as long as he contacts me before he leaves and lets me know where he's going and when he comes back, he needs to
That
contact
sounds
me.
reasonable. All right, so I'm going to permit travel within the continental United States with prior notice to probation on the
Slap
same,
Life for gifting
on the same
memberships
type
to
of pre-notice. That is to
Watchdog.
say, you'll let the
Gwen
probation
Schaefer.
officer know the day before,
Jim
let her know how long you'll be
Fairbrain.
gone. Okay?
Bain, sorry.
If you want to prepare new conditions, I'm happy to sign them. What I'm going to do is I'm going to endorse, I don't think we've
Thank you
docketed
so
this
much.
letter request from Mr. Cody, but I think what I'll do is we'll docket it, and I'll endorse it as allowed, as we've described in open court, and I'll sign new
Maybe that's
conditions
his
for
phone
you.
number.
Yeah, sure.
Okay.
Thank you.
Your motion is allowed. You remain on probation with all the other same terms and conditions.
Okay, thank you very much.
Good luck, sir.
Thank you.
Attorney Gaffney, have you heard from Attorney Angelatas? That's number 12, Calvin Cantave. Have you heard from Mr. Angelatas?
No, he was only appointed for arraignment only. He couldn't take it. It was continued to today to try and get him an attorney.
Yeah, that's
Okay.
why
So, Mr.
we
Gavigan,
always
we have
have like
another
3 or
case
4
for
easy
you.
cases. Today, that's just
Who's
enough.
in lockup?
So
Mr. Calvin
there's nothing new
Cantave.
to it.
Sorry, I didn't.
Sure.
Yeah, just go through all the
I'll
easy
try to
cases
print out the
before we
docket
get
when I have a
to
moment.
the big one.
Do you want to give him any information
Well, we
that you
didn't
can?
ask the judge this time.
Thank you. So second call on number 12.
Okay.
So we're still waiting on Attorney Bradel. We do have the plea on Mr. Bao that,
Thank you, Michael Dutz.
Canceled,
Thanks
but
for
then
the
put
quality
back on the
ongoing
list.
coverage.
Oh, I didn't see it on the list, so it is
I
definitely
like
going to
it
go?
when you
Fine,
lie,
it's
but I
a-
did my
Okay.
best.
error by our
Thank you for
office.
being here today.
All right.
So I printed out the docket. Do you want to do that?
And we have the arraignment too.
We need to finish interpreting.
Oh, we need the interpreter for that, okay? Sure.
Okay, so,
I can
next before the
almost
court,
make it to the Halloween party.
Commonwealth versus Japheth Bao. 24 CR 199, a custody. Have you done a waiver?
Grant Streamside claims there's a
Oh, I'm sorry. Okay.
fake victim
So
surprise
if you
hearing
could just
today,
identify
too.
yourselves for the record.
Good afternoon, Your Honor. Gordon McLeod for the Commonwealth.
I have good mods and they haven't
Good
seen
afternoon,
that.
Your Honor. Dan Mitchell, on behalf of Jeff.
The kid is
Okay.
losing it.
Yeah.
Attorney Bradle was president on the other case.
Okay.
Baker, tell them to hurry
Let me
up. I
see
have
at the
work to do.
sidebar.
Move. Get out the way. Get out the way. Dave has job to do. No, but it's hopefully, normally they have like 5 cases. What? Now they turned off the camera too. They don't normally do that when they go to sidebar. Everyone wave at Aidan. Hey, Aidan. The over-under on him being in his underwear. I would. I know Dave, when he is doing court from his treehouse, he is always naked from the waist down. He calls it Winnie the Pooh lawyering. I know he can't see me. It was a joke. We need something to do, and I can't do the reenactment again. How you can get pregnant to an air vent in a prison, because this is a classy crowd we have here now. It's not like the morning crew, Sue and others. Yeah, Bradle is in court. Mark Betterow is on the Zoom call. But again, it's not Aidan's case that's that's the wrong one. It's not Aidan's case today. It is his case, but it's actually Karen Reed's case. It's the same thing when they did the sneak attack, not advising Karen Reed that they called Aidan in. It's just the opposite way now. So, yeah. I agree, Mess. I agree. Well, go back to right after I came back for lunch. I made a visual of how I believe he deposited his baby swimmers. Yeah, it's filed under his number, and it's the same stupid thing where they filed under Karen's number, but called Aidan during the trial. I wish I could have seen Brennan's sphincter when they entered the courtroom. You could just see him tightening up so fast that he could turn a piece of coal into a diamond. Yeah, that's when they stormed the courtroom, because they filed it under her number, but they didn't call her. And today, because it's her phones they want back, so it's related to Aidan's case. Yeah. Do that. What? I'm sorry. Marissa has been day drinking. What? Hey, everyone. Apparently Doink is streaming me. Let's everyone say hi to Doink. Hey Doink, how you doing? You absolute lunatic. Stop smoking weed, it makes you paranoid. I'm trying to sit and explain things like he does it. So, he cut me out. Son of a bitch. It's because he's good enough to use OBS. I can't do that. But, did he cut out the bottom of it? Is he only showing the screen? Grant Smith Ellis. Yes, they should be in the courtroom. Marissa, has he cut the button, or can I put a... Oh, yeah, I can just do this. Sorry. Oh, he can... Hey, Doink. Grant, if you want the link, just hit me up on Twitter. I know you have me blocked, but I'm a nice guy, even if I think that you are absolutely way too unserious to be doing this, because you're way too stoned. I'll send you the link. It's no problem. Sharing is caring, but thank you so much. I hope, as a good boy, you did hit the Lindsey had the same epiphany. She just learned how to write kinda like a trial attorney. Grant had nothing to do with it. Because if he did, he would be breaking the rules. And Grant is a very, very moral guy.
Second call
who will,
on Mr. Bao.
maybe Lindsey Gaetani is a double agent
7 and
working for
9,
Aidan.
Counsel versus Aidan Kearney, 23 CR 313,
Yeah.
24 CR 43, 25 CR 88. If the Mr. Kearney joins us via Zoom, if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Okay, Mr. Cosgrove?
Hello, Your Honor. Timothy Bradle for Mr. Kearney. Good to be with you.
Okay.
Good afternoon, Your Honor. Attorney Steve Buzang on behalf of Ms. Reed.
All right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004, but it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay.
Did you fuck up a timeline again? So he...
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second.
These phones must have been searched in the criminal case because they have tried and indict her before a grand jury before. Now Cosgrove is just fishing, so they must have it. But it's interesting if there was a deadline that he missed.
Yeah, so in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the log-on information, or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Move on.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed, and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right.
There was a ruling last
month. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the content of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, right. Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud, or blood, or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the 4th Amendment and Article 14th of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant without unreasonable delay. And
here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right, no, I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
No, because there's no speedy trials, and he just said, yeah, well, there is a limitation that was set last month, but that's only in warrantless searches of phones. But they had a warrant on that one, and then you can keep it forever, even though...
You know, I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the 4th Amendment, I think again, this would have, I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation when they've had the investigation was done, and there was nothing to it.
But she's not criminal.
If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But I think in terms of reasonableness and timeliness, Judge, I think, you know, it's almost 2 years.
Okay, I'll take it under advisement.
And the matter, it does have a next date of December 5th.
You know what? I'm sorry, Margaret, I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
You know, I do, Judge. I don't think the Commonwealth, you know, in the preventive medicine case, the defense has some say in, you know, who would be a part of the taint team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for the with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over, I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two phones. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
opposition to what?
To the taint team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not a elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before, okay? It's not all that complicated. So I'll give you 10 days to do that, if that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
I'm happy to talk to Mr. Booth.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8th. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 10:21.
Okay. We'll await your responses. You have until October 21st. And the matter is next on December 5th.
Thank you, Your Honor. Thank you, Madam Clerk.
2 p.m. for hearing on the motions to dismiss. Thank you. I'll see you then.
Your Honor, may I be heard on the disqualification issue?
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as an in-ray search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6. I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not. I will not. I'll put you on for a hearing on a motion for disqualification, but I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure, I understand. Your Honor.
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but let me, do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted for the public docket, and there should be an unimpounded one, or unredacted one, rather. That's for the court. And I believe they were filed in all three of those dockets. The 24 and the 23 case for Mr. Kearney, and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but.
I think they might be downstairs. I didn't think it was being
Sure.
today, and the files are so voluminous.
Okay. What's the status of the 2025 case?
The
25 CR 88.
that's had a little bit of a back burner, Judge. I think there's a pretrial where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
Correct. The 24 case on the part of Mr. Kearney, Mr. Cosgrove acknowledged and withdrew. The 23 case we contend.
I'm sorry. Say that again.
Sure. The 24 case on the part of Mr. Kearney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gaetani is suing him and is also a key witness in the 23 case by the government's own admissions. The detective on the case swore to it.
Yeah, that's fine. So you haven't filed a motion to withdraw on the 2025 case?
Correct.
Okay, so we'll take up the 2020. We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th, in November at some point? And if we can't get a date right this second, can we report?
Oh, you can get a date right this second? Okay. We'll figure it out.
Sure.
December looks better to me than November, Your Honor, and part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradle has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office, is who should respond to the motion to disqualify me. Should I respond? Should or can the Norfolk District Attorney's Office respond, or should it be the Attorney General or someone else? So there are discussions underway as to who the appropriate person is to respond to that, and I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date December 5th?
We do, Your Honor.
All right. It should be here. Yeah. What? No.
I will move it.
Yes, it should be in this session.